Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna, PC. This is our bi-weekly community conference call, not intended to create attorney-client relationship, as you would have heard when you logged in. You may want to keep your identities confidential because this call is being recorded. It will be publicly disseminated. Today is February 9th, 2017, and as usual, I will first go over all the questions I consider to be frequently asked questions. When I ask you to, you can raise your hand for any follow-up questions on what I'm discussing using *5 on your telephone. Okay, first question is from GS, contact GS. This relates to extension of H1 beyond 6 years. There's a gap in H1, late in filing PERM, etc. Well, I think a lot of you already know this, but I'll repeat it. Under the current rules, there are two ways you can get H1 extension beyond 6 years. One is based upon the time your green card has been going on, and the other one is based upon the stage you are at. We don't care what time the green card was started. Time-based and stage-based. Time-based works like this. The day the first anniversary of your PERM filing is reached, you are entitled to a 1-year extension of your H1 on a year-to-year basis. Stage-based green card, the day your I-140 is approved, you are entitled to 3-year extensions. So those are the only two ways. What if you are late? What if you have only 8 months left on your H1 when your PERM is filed? Well, if there's a 4-month gap or a 2-month gap or a 3-month gap, you would either have to convert to another status or leave USA, and then you come back when your 1-year time is mature or stage-based green card is activated because your I-140 is approved. Let's go into GS's questions. He says she says, my H-1B visa is going to expire Jan 2018. They have submitted my PERM in June, so we've got only 6 months left. If my PERM gets approved before my current H-1B expires, can I get H-1B extension? No, but if your PERM gets approved, what you can do is you can file for your I-140 premium processing, and if the I-140 is approved before the current H-1 expires, you'll be entitled to 3 extensions. If it is not reached I-140 approval stage, you can try to apply for conversion to like a tourist visa or a student visa or leave USA for a couple of months while the I-140 is getting processed. Second, if my PERM gets approved after my current H-1B expires, can my employer file for H-1B extension of 1 year since my PERM is approved? Again, PERM approval is not the criterion. I-140 approval is, or PERM pending 1 year is. So if the I-140 is approved, your H-1 can be applied for, yes. Would I need to go back to India? I just described that to you. Can I recapture 2 months? And the answer is yes. You can recapture 2 months. And there is no requirement that a green card must have been filed first in order for you to recapture your time outside USA. Anybody who has a follow-up question on what I just discussed, press *5. Anybody who has a follow-up question on what I just discussed, press *5. Next question I get asked quite a bit. How can a US green card holder study abroad without losing their green card? This is a very interesting situation where somebody wants to go to Poland to study medicine. It's a 6-year program. There are two components to maintaining your green card. When you leave USA, there must be an event, the completion of which is quite likely to occur within a reasonable period of time. For example, if I'm going to go outside USA to dispose of my land, my real estate, chances are it will get done in a relatively short period of time. So I could go get re-entry permission to stay away for 2 years. Now, what if I want to go for 6 years? Well, that's a little tricky because it does not meet one of the criteria. Speaking off the top of my head, I haven't researched this issue. It does not meet one of the criteria, which is the event is likely to get wrapped up within a relatively short period of time. I know many people, many people who have done this, at least for countries where the study of medicine is 4 years. It appears to be quite straightforward. We haven't had a problem. All I can tell you is you can certainly try. I think it should be researched specifically to see if there have been any issues in situations like the one you present where you want to go for 6 years. So re-entry permit must be applied for. There is no doubt in my mind. Normally, people have applied for 2 or 3 re-entry permits and it has worked out. How many re-entry permits can you receive? Actually, there is no limit that I know of. I know of cases where they've given 2 or 3 extensions easily. And I also know of cases where after 1 or 2 extensions, they've dropped down the extension to 1 year instead of 2. If you plan to return to USA for 3 months in the summer and for Christmas holidays, that is probably not enough to keep your green card active. If you can enter USA every 5 months, I would say after first extension, maybe after 4 years, you should plan on applying for an extension, but keep coming back more frequently. And again, going back to Sandra's question, what should I do to show up ties? I can only guess that in a situation like yours, since there is a specific reason why you are leaving USA, re-entry permit is not a guarantee of being able to keep your green card, but re-entry permit is your declaration that I want to keep my green card. Even though I'm going away for a long period of time, I want to come back. So as much as a guarantee is possible, re-entry permit is it. There's nothing else you can do. Sandra, if you are on the phone, press *5. *5 if something is not clear. Anybody has a follow-up question on what I just discussed, press *5 on your phone. Okay. Next question is a frequently asked question about automatic EAD extension. The way this is going to work is this. There are 15 categories of EADs where if you have applied for the EAD before the expiration of your current EAD, when I say apply, the application must reach USCIS before your current EAD expires. So if you have timely applied, your EAD, and there are certain other requirements. It is in the same category that you had earlier gotten the approval for. There's some exceptions for TPS, temporary protected status. But EADs like L2 and H4 don't get extended automatically. But I-485 based EAD gets extended automatically. And I just sent an email out yesterday to all our corporate clients about how to fill out the I-9 in these cases. So when you have a 485 pending and you have an EAD based upon a 485 approval, if you timely file, you can continue working for up to 180 days even after the current EAD expires. Also, USCIS has indicated that they will allow us to file I-485 EAD. Well, let me rephrase that. EADs 180 days before the expiration of your current EAD. So there are two 180-day periods. One 180-day period is you can apply that early. It used to be 120 days. And the second EAD period is it gets automatically extended if timely filed. Star 5 if you have a follow-up question, folks. Star 5. Press star 5 on your phone. I have one question. Illinois, go ahead, please. Illinois. Illinois, go ahead.
Yeah, hi, hello, Ajay.
Hello, sir.
Thanks for answering the original question. I think my follow-up question is, what if even after that 180-day expiration of the extension, the EAD doesn't come?
You cannot work anymore, but you are in legal status.
Okay, so I can stay in the country but cannot work. I have to be off the payroll.
Yeah, you can stay in this country because you have a 485 pending. Okay.
Understood. Thank you very much.
You're welcome. Good luck, sir. Okay, I think that was it. All right, let's go on to the next one. US citizen applying for green card for brother or sister. How long would it take? About 13, 14 years? Do the kids, wife and kids automatically get green card? Yes. The children who are below the age of 21 when the green card is obtained and spouse automatically get green card. Don't have to apply for them separately. But there is something called Child Status Protection Act, CSPA, which allows you to deduct the number of days the I-130 was pending from the age of the child. So just a general rule. That might be something to keep in mind. They won't get an EAD until their dates are current, and that takes 13, 14 years, and they can't stay in the USA. You can have a green card pending through as many categories as you like. Employment, family, two employment-based green cards. All of that is okay. But you cannot expedite a green card just because you have multiple green cards pending. So there's no advantage to it, but you can have multiple green cards going. The employers, see, just because somebody has a PhD does not make them automatically capable of getting a green card in a higher category. But EB1A, EB1B green cards are available if they meet other requirements. If you go to immigration.com, our website, and you go to green card and citizenship, I'm actually trying to point that out. You have there EB1 category priority workers defined. So you could take a look there. It explains to you the criteria. Feel free to post a message there. Star 5 if you have a follow-up question on this. Star 5. The point I was trying to make, which is very important, is just because your brother or sister has filed for you does not make you eligible to stay in the United States. So this is from Raj, who says, how do we keep up with rumors and changes in the laws? Well, I guess I can only speak for myself. You can follow our social media. We'll be happy to share whatever we know, and we do anyway. Immigration.com, my Twitter account, Facebook, Google+, LinkedIn. There's plenty of, if you go to immigration.com, on the top, you'll see all our social media, YouTube, Twitter, Google+, LinkedIn, Facebook, Pinterest. So you can follow any of those, like Twitter accounts or Facebook or LinkedIn or Google+. I do keep everything updated as best as I can. You can always ask us questions if there is a rumor and you're not sure about what's going on. You can tweet to me, you can send me a LinkedIn message. I do my best to respond. So, what are all the new changes? If you go to my blog, I actually keep everything updated. For example, it tells you you can travel internationally or domestically unless you are from one of the 7 countries. Trump's executive order. I keep these things updated pretty much. So you can always log in there to see what's going on. My I-140 is approved, Raj says, in 2013. Priority date is 2013. Do you have any insight on country quota elimination bill? Well, there are 5 or 6 bills pending, I think, before the current Congress. So I don't know what's going to happen. Should I change a job now or should I wait? Don't wait for any bills to pass because there's no guarantee that any bill would pass. Bills take a long time. I personally feel that under the current rules, if you change before 485 filing, you have to start the green card all over again. But if your I-140 was approved for up to 180 days, you keep your priority date as well as your right to extend your H1 through any employer, even past 6 years. Star 5 if you have a follow-up question. Star 5. Okay. Again, another frequently asked question, should I travel outside the USA H-1B visa stamping? If you are not on the list of those 7 countries, people are traveling. I did update my LinkedIn account with a detailed conversation about how people are traveling and coming back. It isn't the end of the world, but overall, I think H-1B visa stamping was always complicated, especially when you work at a client site instead of in-house. So that's not becoming any easier. And when you re-enter USA, government does look at your paperwork. If you're approved to work in San Francisco and you're working in Akron, Ohio, they're not going to let you enter. That was always the case. That law hasn't changed. Is it risky to go to India for stamping? I think it's risky. It was risky before as well. What all precautions should we take? Make sure your papers are reviewed by your lawyers. Make sure that all the H1 required conditions are being adequately met and that you are not violating any conditions. I think if you need to travel, you should go for stamping. I can't really comment about your need and how urgent it is. But if the travel is merely discretionary or optional, then don't travel. Getting H1 visa stamps was always a hassle, and it certainly hasn't gotten any easier. Star 5 if you have a follow-up question. Star 5. Okay, no question. Another frequently asked question, okay, there is one. Let's go back to traveling and getting H-1B visa stamped. We have 2 questions on this. Let's go to the first one. California, go ahead, please.
Hello, Rajesh.
Hello, sir.
Can we get, yeah, how are you?
Good, how are you?
I'm doing good. I had a weird question, but I'm not sure whether this is a valid question or not. So can a H-1B person work in 2 places if he has 2 H-1Bs? Is it valid or how is it?
No, definitely. It's called concurrent H1s. And I always like to tell the story of a client of ours some years ago. He had 3 full-time H1s running concurrently. So at one point, when I filed the 3rd one, USCIS said, how can this guy be working 3 full-time jobs? How can he be working 120 hours each week? We had to explain to them that he was a database administrator and his job was to be on call. So he was on call full-time for 3 different companies. And even though he actually went in very rarely, being on call was his job. So that's what he got paid for. As long as there are enough number of hours in the week, you can have as many jobs concurrently on H1 as you like, but each H1 must be approved. You can't just have one H1 and work 3 different employers. Okay.
Okay. Okay. Another question though. One last question. So, is it safe to work, or the employer says you can? They will send the H1B documents basically to the USCIS, and they have a FedEx number kind of thing. So you're saying you're fine as long as they get the documents. You don't need to have the VAC number.
Well,
is that a valid argument?
There are actually 2 points of view on this. My point of view is relatively conservative. I prefer to get a receipt before I get somebody started. And if you file premium processing, the receipt comes through email. But definitely there is a point of view that physical receipt of paperwork is all that is needed. You don't actually have to wait for the fees receipt. There are 2 points of view. Mine is the more conservative one. Okay?
Okay, so you don't need to have a VAC number to start at a new position.
What I said was that is one point of view, it's not mine.
Okay.
All right.
But the safest option to have is a VAC number.
I prefer that. I certainly prefer that. Good luck, sir.
Okay. Thank you.
You're welcome. Let's go on to Pennsylvania. Pennsylvania, go ahead, please.
Rajesh, good afternoon. H1B stamping, right, in US consulates abroad, is it still the drop-off facility is available, or after Trump's government is just stopped? Any idea?
I got an email yesterday from a client. They just applied at the Dropbox. I think it's still working, yeah.
All right, thank you.
Oh, you're welcome. Good luck. Okay, let's go on to the next frequently asked question. This is another one that's quite tricky. When is an H1B amendment required? USCIS has given us a relatively incomplete memorandum that currently says this. If an employee relocates within the same geographical area, which is normal commuting distance of an approved location, they do not have to file an H1B amendment. Now, this is an incomplete story. This is not a complete story. The memorandum is misleading, and we've been advising our clients to work according to my suggestions, not depend upon the memo. First of all, even if you go by the memo, language of the memo, remember, USCIS and Department of Labor has different regulations. So just because the memorandum talks of USCIS regulations does not mean you've complied with Department of Labor regulations for change of job locations. Department of Labor says any new location, even if it is in the same building, you must post the LCA notice there at the very least. So even if you are moving within the same area, LCA notice should be posted, which brings me to the point, might as well just do a new LCA. So each time you move, even if it is in the same neighborhood, I would recommend doing an LCA amendment. The second way this memo is misleading and incomplete is this. What if I change jobs next door, but my job description changes completely? I think you would have to, in fact, I know that you would have to file H1B amendment, even though it is the same neighborhood. What if my client changes? What if my project changes? I think in all those situations, again, the conservative thing to do is to file for an H1B amendment. But if you wanted to be aggressive and did not file an H1B amendment, at the very least, the job description should remain the same. Job description, salary, etc., if they are similar or same, I think you have a defensive argument that you're following the memo, the matter of Simeo memorandum. So, but the smart thing to do is to file an amendment in all cases except where the location is local, relocation is local, and in the same project with the same structure of vendor, sub-vendor, subcontractor, whatever that structure is, and the end client, everything remains the same. If there are variations in any of those things, the smart thing or the conservative thing is to file an H-1B amendment. Star 5 if you have a follow-up question on this. Star 5 if you have a follow-up question on this. There is, from Mani Shankar, there is another part of this question. My wife is on H-4, she wants to travel, and if I haven't done an amendment, is that okay? I think it's safe to travel, as safe as it was before. Trump so far has not corrected, quote unquote, anything in the H-1B, H-4 area. What tomorrow brings, I do not know. Let's go on to the next frequently asked question. Job promotions, let me just check my Twitter account also. I usually monitor that as we are talking. Okay. So what happens if I get promotions during AC-21 portability of green card? I strongly advise you to take a look at this chart I had made. It's right here on immigration.com. It actually, I think, is quite comprehensive. In green card portability, it talks about same or similar job is still necessary, but USCIS is not going to look at only a confined set of documents to arrive at what is same or similar. Career progression, which means promotions are okay, even self-employment is okay. So this chart is, I think, pretty useful. I constantly refer to it, as do many other lawyers. It took me about 2 hours to prepare this chart, but I think it's well worth it. So review it. You will find a lot of information there, at least enough to get you started. So going back to the question that was posted by Raj, it says, my I-140 EB2 is approved. Different employer is offering me Director of Development Services job. But the thing is, Raj, one thing I don't see is, have you filed 485? Because if you have not filed 485, it doesn't look like you filed 485 yet. You'll have to start your green card all over again. You can get an H-1B for any professional job. So getting an H-1B for the director position should not be a problem. And you have to start the green card all over again. When you have to start the green card all over again and you're just taking the priority date forward, your jobs can be completely different. They don't even have to be same or similar. It doesn't look like you have a problem. Star 5 if you have a follow-up question on this. Star 5. Okay. This is California. Let's go ahead and select that. Yes, California, go ahead, please.
Hello, Rajiv. Thanks for answering my questions here.
Of course.
So my main question is the H-1B transfer. So like I said, my current H-1B filed as a software engineer. So the job description and all that will be different. When I do H-1B transfer, does it have to be the same thing, or it can be different?
H-1B law was always very clear. A person in your situation has no problem. So if you went from director to vice president software development or to chief technology officer, all of that is okay. Why? Because the degrees and the qualifications required are all degree in computer science equivalent with experience. So because it's a natural progression in your own field, I don't see any problem. In fact, let's take a little bit of a different example. Let's say you are a database developer, or let's say you are a database administrator. You administer Oracle database on Windows and Unix side. And then you decide, you know what, I've gotten bored of this. And I want to let's say, get into development, or I want to get into, give me 1 second, they're trying to reach me. 1 second.
Sure.
Sorry. Let me just log out. I forgot to log out, so the team is trying to, I don't know what to do. Just leave it alone for now. Okay, so going from a database administrator to, let's say, a developer doing Java development is not a problem, because if you have a degree in computer science, that's all we care about. So taking your example, if you go from software engineer to director of development services, after all, if I have a degree in biology, I won't be able to do your job. Because I have a degree in computer science or electrical engineering or information systems, I can do this job. That's all H-1B cares for. Does your job require a specific degree? Okay?
Okay. So the transfer should be fine, basically.
It's no problem at all. Go for it.
Okay, perfect. I do have a basically suggestion that I need from you. If you look at question 1, the EB2 is the current date is 2008.
See,
2008.
that is such a difficult decision for me to make, Raj. But the thing is, the way I would look at it, if this is an opportunity which is very important and key for your career, and they're not going to wait for you, then might as well jump ship. I don't see why not.
Okay. Do you see any days moving sooner? Any chance?
Only the good Lord can. Only the good Lord and the Department of State knows that. So, no idea. Sorry.
Sure.
Okay.
Certainly. I appreciate your help. Thank you.
Good luck. Okay, let's go on to this one. Is also California. Yeah, California. Go ahead, please.
Hello, Gigi.
Hello, sir.
I have a separate question. So, my employer has filed for H-1B in premium processing, and I got an RFP as well for the premium processing. So, they are planning to reply to the RFP. So, does that mean the USCIS will reply to the US to the RFP application, or would be sooner, or how does that happen?
This is not a related question, so I'm going to have to put you on hold for that. Ask me only questions related to what I'm discussing, please. Okay? Let me put you on hold. Okay. So going back to our other. Now, this is another very interesting question about. I just noticed a typo here. J1 physician applying for following to join after waiver. You see, for J1s, Sanju, what happens is, it's very common. I've done this before several times. So let's say the husband is on H-1B visa. He's a software professional. The wife is a physician, and she's doing her 3 years waiver job, or she's applied through Veterans Affairs or through Health and Human Services, HHS waiver, whatever the waiver is. And she's doing her time there, but he gets his green card. Let's say 1 year later, she's got her waiver completed, or she's left USA for 2 years. Can she come back? Well, yeah, she has 2 choices, and she can do both of them together. One is to apply for a green card through him as wife, which is family-based, I-130. And the second is to do following to join, which says, we were married when he got his green card. Therefore, I'm entitled to his green card. I wasn't able to get it then because I had this disqualification of waiver required or 212E home residency required. But now I have completed that or gotten a waiver or completed my waiver job time. Give me a green card through him under the employment-based category. And you can apply for both of them. We had a client actually who had to go back to India and do her 2 years before she could apply, and she got her following to join. So let me go back to your questions. I'm a physician doing 3 years. I was in the I-140. Is there a possibility of filing my 485 directly? Yes. Yes. If you are in USA in legal status and his priority date through which he got his green card is still current, you should be able to file your 485 directly. And you can also file I-130. You can't file 485 with that I-130. Also remember, you can no longer do following to join if he gets his citizenship. Okay? So if he gets his citizenship, then you should apply through his spouse, through the family-based category. Star 5 if you have a follow-up question on this. Star 5 if you have a follow-up question on this. Okay, there is one. This is...
Can you hear me?
Yes, New York. Go ahead, please.
Hi. So I have a question regarding the hedge fund 7th-year extension and the change of job.
Ma'am, I'm not opening the floor for new questions. This is just follow-up questions. Stand by.
Oh.
Okay, going back to impact of I-140 approval after 180 days. I have an approved I-140 with priority date of 2013 from employer A, and A will withdraw my case. Employer B is filing for I-140 now. Can I go with premium processing? Sure, why not? Will there be a chance for query if I go with premium processing? I don't have any such experience. We file any cases where the client is willing, we file them premium processing. My 6 years of H1 will be expired in December 2018. Will this affect my current H1? Typically, no. The cases that have already been approved should not be affected by anything that Trump does. He can only affect things prospectively, whatever happens in the future. Okay. So I think those are your questions. I'm not sure why I marked it as a frequently asked question. It doesn't look like a frequently asked question. Star 5 if you have a follow-up question on this. Star 5. Okay. Let's go to the normal questions, which are non-frequently asked questions. This was a frequently asked question. All of these are okay. Now this one is from Sina Roxanne. I'm not sure if I'm reading this right. Born in US, I'm a born US citizen. Husband is from Morocco. We applied for his green card. He got his 10-year unconditional green card. Okay. Do we still have to wait 3 years from the date of his being granted permanent residence to file for naturalization? No. First of all, even if he got a conditional green card, which he did not, you could apply 3 years after he got his conditional green card approval. It isn't required that you have to wait for 3 years after getting condition removed. If you are married to a US citizen and living with them, you can apply for your naturalization 3 years after the green card approval, whether the green card is conditional or permanent. So I'm not sure if there's anything else. USCIS, so you already filed for. You should check. It looks like you're just facing normal delays. When did you file for your naturalization? Your husband's naturalization. I hope you're here. Star 5 if you are on the phone. Star 5. Press star 5 if you're on the phone. Okay. It looks like you're talking about just normal delays of a naturalization. Your case should be approved as long as he filed 3 years or 90 days within 90 days of the 3rd year anniversary of his green card approval. He should be able to get his naturalization. I don't see why not. Any follow-up questions on this? Star 5. Okay, let's go on to the next question. TP says, I'm an Indian citizen working in US. AOS is pending. EB3 category, priority date of July 2007. I-140 approved in 2009. Don't have an H-1B. My fiance is an Indian citizen. Good job and career. What are my options for filing for his immigration? Do I have to get an H-1B? So do you have to bring him here on H-4? No. You can split the process so that you get your green card here and he gets to interview at the US consulate in India, what is called following to join. One problem though, it'll take a few months extra, 9, 10, 11 months extra, maybe more, after you get your green card for him to come. You can also convert to H1, bring him here on H4, or actually just get his H4 visa stamped, bring him here on H4, file his 485. Once he gets his, well, actually he can travel without the advance parole. Send him his advance parole to India. That way, when you get your approval, he gets his approval as well while he's still living in India. And he can travel on that green card then. So that appears to be an option. The only problem with following to join is that there is a gap then. You have an extra 10-month period, 11-month period, or even more of separation. *5, if you have a follow-up question on this. *5. California, go ahead, please. California.
So if we do the family processing, where you said it might be 10 or 11 months,
hang on. You have to be married. You cannot do any of this processing before marriage. It's required by law that if he wants to get his green card through your employment-based case, you must be married on the date the green card is approved. And what he will be doing is then called following to join. It's not family-based. Family-based would be different. Family-based would be you get your green card, then apply for him separately.
Got it, sir. So the only question I have is, if we were to get married and, before this, so I have to notify USCIS in some manner. And is that the following to join application?
Yes, it's a form called Form I-824. You send that to USCIS and inform them that I'm married. Once my green card is approved, forward a copy of my file for consular processing to National Visa Center in New Hampshire, who would then process the case, get you involved in the process, and send the papers for your husband's interview in India.
And would there be any risk to my green card approval if I were to file for this?
Not even 0.0001%. No risk.
Oh, thank you.
You're welcome.
Thank you, sir.
You're welcome. Okay, so let's go on to the next one. Rajan, JJJ, I'm an LPR, M400 is processing. Speeding ticket from Colorado 14 years back. It's not a problem at all. You paid the ticket. Should I be worried about the executive action for crimes? A traffic ticket is not a crime. Don't worry about it. *5, if you have a follow-up question. Don't worry, this is fine. I'm not concerned about it. Okay. Anil Kapu says, I currently hold an approved H-1B petition, but not stamped, valid till October 2017. Wife's organization is filing for her L1A. Can I go? So the question is, I don't have a visa stamp. Can I still be visa exempt? When I come here, can I go to H-1B? So the answer is we have received these kind of approvals. If you ask USCIS, they will tell you, unless you get a visa stamp, we consider you to be still subject to the quota. But as a practical matter, in fact, last week only, we received an approval where a gentleman had not received an H-1B visa. They just had an approval from a prior employer, and USCIS gave us the H-1 exempt from the quota. So it looks like you should be able to get a quota exemption. But like I said, if you ask USCIS, they won't tell you that. Will my stay in USA on L2 count against 6 years? No. L2 does not count against H1B. Let's see. I'm hoping this is a follow-up question on Anil K. Kapoor's question, because we haven't opened the floor for new questions. No new questions at the moment, please. Okay, India, go ahead. You have a follow-up question?
Hi, Rajiv Ji. Yeah, hi, Rajiv Ji. This is Anil. Thanks for taking up this question.
Of course.
Yeah, so my question is, as I said, like, I don't have the H1B petition stamped yet. It's just a approval,
right,
which is valid for now. My plan basically is to, once I go for L2 interview and once it is approved, when I join my wife in US, I would like to see if I can work in H1B rather than L2, because I don't want to be dependent on L1 visa.
Yeah,
so,
like I said, we have received approvals. So I think it should work, but like I also said, if you ask USCIS, they'll tell you until you get the visa stamp, we still consider you to be subject to the quota. So you decide which way it works. I think it's worth trying. Okay.
But the thing is, I don't have that employer still like having a job for me now. I need to find a new employer.
Well, you cannot do an H1 without an employer. You cannot do an H1 without an employer anyway, right? So.
Yeah. So my thought was to find a new job and get this existing H1B petition transferred.
I'm lost. Like I said, I think you could go through quota exempt status. I'm not sure what you're asking me, MLG.
Okay. But no, what the question I'm asking is, since I don't have a current employer who sponsored the existing H1, can I find a new employer who can transfer that H1 once I am in US?
Yes, of course. That is the only way this question would make sense. If you're going for the same employer, things would be a lot easier, right? So yeah, and the answer is, in my opinion, yes, you can.
And one last question on the same thing is, since I need to go to L2 visa interview, the process dependent interview now, will there be a chance that the consulate officer revoke my current H1B petition, seeing that I already have a valid H1B petition?
Can they revoke your H1B because you're getting an L2? Is that what you're asking?
Yeah.
I don't see why or how. That is not the usual process. I don't see that as a problem at all. Okay.
Okay.
Good luck, sir.
And so L2 duration in when I'm in US, the duration in L2 is not getting counted for my H1B, right?
Yes, that is correct. It is not counted.
Okay.
Right.
That's great.
Good luck, sir.
Thank you, Rajivji.
You're welcome. Bye-bye.
Thank you.
Okay. I just got a tweet that I was looking at this question about how do we keep up with the rumors and all. There was something else here. There's nothing here, Raj. I don't know what else you're saying. Press *5 if you're on the phone. Raj, you just sent me a tweet. Press *5 if you're on the phone. There's nothing about your wife here. You said you were asking me about your wife. How to keep up with change, but is about how to file for spouse. Don't know where that question is. Okay, well, sorry, I don't know where you are. I'll have to go on to the next question. This is from Banyan Tree. My son is a junior in high school. He would like to take a bachelor's degree in business administration. He's still on H4 visa. Would it be possible for his employer to sponsor H1B, on a non-technical degree? Well, it depends upon the nature of the job. If the job requires a degree in business administration, that's okay, because business administration is not a non-specific degree. Not all H-1Bs are given for technical degrees. They can be for non-technical degrees. For example, a psychologist. That is not a technology-related degree. Or maybe an accountant. So it is possible that there is a job out there that specifically requires a degree in business admin. If that is the case, they would be able to get an H-1B for that job. Now, OPT they won't get, because for OPT you have to have been on F1 status for at least 2 full semesters. So unless they convert to F1, OPT is not an option. *5 if you have a follow-up question. *5. Okay. Raj says, Raj B1234, valid I-140 approval in 2003 by company A, and I filed a 485, used AC-21 to change over, moved to India in 2010, closed the 485. Can employer C start the green card process? No. Because if you close that case, only thing you can hope to salvage from them, you can, if you go with employer C, you can only take the priority date. But if you join the same employer who initially started your process back in 2003, there's potential to file directly the I-485. There are issues here. This is not a simple situation. One issue would be, did the job stay open for you all through these years? If so, why did you leave? So those kind of questions can be asked. But if you joined employer A, you could certainly try to apply for 485 directly. *5 if you have a question. *5. Follow-up questions only, please. Okay. Krishna wants to know, EB2 approved, priority date 2010, contractor, but don't want to travel to India. If I stay in India for a year or so, will it affect my green card processing? Go through our frequently asked questions. We've discussed this issue many times. And my concern is always, one, does the employer who sponsored you continue to have the ability to pay you, even though you're not in the payroll? And two, do you really have the intention to take the job? If so, why did you leave? 3, is the job still open? Did it stay open? Who else was doing the job while you were gone? What can the employer do to help? Well, you see, these are the questions that need to be answered, the ones that I mentioned. As long as they have good faith answers, honest answers to all these questions, you can definitely take a break and go to India and come back when the time is right for you. *5 if you have a follow-up question. *5. Okay, let's take. Go ahead, Washington, D.C., go ahead.
Hi, this is Trupti. I haven't posted any question, but I have similar questions on I-140. Can I ask?
If it is a similar or a follow-up question, yes.
Okay. Yeah, so my I-140 is approved in 2013 in a EB2 category. And now I'm in the process of changing the employer. But my current employer, he's not providing me I-140 copy. And the new employer, they want it, and without that, they don't want to go ahead with the process. So is there any way to get a duplicate copy from USCIS or any supporting document I can provide to the new prospective employer?
Yes, you can file a Freedom of Information Act request.
Okay, but I think that takes a lot of time, right?
Couple of months, maybe a little bit more. I have filed H1 extensions without an approval notice with just the name of the employer and your name and social security number.
Okay. So I should get it in a couple of months if I go with FOIA.
You can file the FOIA. I don't know how long it will take. I'm just making a guess. You can file the FOIA, and you can also talk with the employer's lawyers, new employer's lawyers. They should be able to file for the extension without having a copy of the approval.
Yeah, that's what I'm trying to explain them, but they are picky about that and they want a copy of I-140 approval. I have the email though which USCIS sent for the I-140 approval, and it has the priority date, it has the category, the beneficiary and petitioner name. So it has everything, but they want the actual copy of 140 approval.
Well, if you don't have it, you don't have it. So the best you can do is ask the government under a FOIA request, see what they give you.
Okay, that's the only chance to get it. There is no other way.
No, ma'am. I don't know of any other way.
Okay.
All
okay. Thank you so much.
You're welcome. Okay. I think I just covered this, didn't I? Okay. So the next question is, I have an EB3 based immigrant visa under consulate processing. My priority date is 2004. I left USA for Canada and I've got package 3 in Montreal, job offer, but the company has dissolved. I don't think you can move forward with this application. Only thing you can do is take the priority date of this application and start a green card again with another employer. *5 if you have a follow-up question. *5. So you cannot really go forward without the same employer. That's the disadvantage of consular processing. If you were in adjustment of status, you could have done a port over. Canada, go ahead, Canada.
Hi, Ravi, how are you?
Good, sir. How are you?
Good, thank you. So you answered my question, but now, so if I have to start, do I have to start in the same occupation or it could be a different occupation?
Yeah, when you carry forward, when you carry forward the priority date, you can be in any occupation. Doesn't matter.
Doesn't matter, right?
No.
Okay. And since we receive the package 3, how much amount of time do we have to respond, or how much amount of time we have to submit the papers?
The package 3 should tell you that you have 12 months.
Oh, okay. And so in this case, we have to start from the labor, right? Once again.
Yes, sir. You do.
Okay. And usually, if you start like nowadays labor and like I-140, how long normally does it take?
That's very difficult to predict. I would say normal time is anywhere from maybe 6-8 months to a couple of years. Depends upon how many problems that happen during the process. So if everything works beautifully well, 6-8 months, 9 months. If you get into supervised recruitment audits, it could be a year and a half, 2 years, who knows.
So what you mean to say it can be in any occupation, right? Doesn't matter, it has to be in the software engineering or anything, right?
That is correct. Yes, sir.
And do I need an H1 in that case or no, just as a potential employee?
You don't need an H1, it can be a future employment.
It's a future employee. Okay.
All right.
Yeah, and if we don't submit, suppose like in a year, if you don't submit all the documents what they requested as per the package 3, what happens to my file after that then?
The file is considered to be abandoned. There is some rulings that say if the file is abandoned, maybe your I-140 is gone as well. I do not know if that is the truth. That's something your lawyer should research for you. But keep that in mind. Okay. There have been cases where government has taken this position. Okay.
Okay, so do I have to let them know I'm starting a new process, or how do I proceed then?
How do you process what? I'm sorry, what did you say?
I'm asking if do I have to let U.S. Content Montreal that I'm processing new application data, I'm starting from labor again. So do I have to let them
No,
know,
I don't
or
think
how does it work?
I don't think you should do any of that. Contact your
Okay.
lawyers, whoever is going to do your next green card. Discuss the situation with them.
Okay.
Nothing is going to happen overnight if you don't respond to package 3.
Oh, I see. Okay.
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 Good luck, sir.
Okay. Thank you.
You're welcome.
Thank you so much for the answer.
You're welcome. Okay. I just finished that. Next question is B2 visa. Mother entered on B2. I-94 is valid for 6 months. Can she stay for 5 months, 3 weeks later, and come back again? Well, the problem is this. Is it okay to stay in India for 6 months or more before coming to US again? Yes. If you come back too quickly, they can say, well, it looks like you are living in USA and visiting India. So if you are spending in any 12-month period more than 6 months in USA, they could create a problem for your future entry. If it is 6 months or less in any 12-month period, I think you have a better chance of procuring re-entry. *5 if you have a follow-up question. *5. Okay, I just have a couple of minutes, guys. New Jersey, go ahead, please, New Jersey.
Yeah, thanks, Rajiv, for the community service. So, I have a follow-up question on this. So, month 3 weeks is okay to leave before the I-94 expiry date?
Your voice is breaking up. I didn't catch that. What did you say?
Yeah, my question is, this 5 months and 3 weeks is good before the I-94 date?
5 months and 3 weeks stay is good before the I-94 expires. Is that what you asked me?
Yes.
Yeah, I mean, as long as she's leaving within her current period of authorized stay, that entry and exit both are legal. As to the future visit, if she comes back too quickly, they can turn her back.
Okay, sounds good.
All right.
I have a new question, so I put me on hold. That's fine for me, or if you want me to ask now, I can ask.
Yeah, let me put you on hold. I don't even know if I have time for new questions. It's I only have about a minute, and I know that there's a bunch of people who have questions. Tell you what, I will answer the questions who logged in before at 12:30 p.m. or before. Okay, I'll answer your questions. So anybody who logged in 12:30 or before, I'll answer your questions. Anybody else, I won't. You are in that range, so stay on the phone. So
okay, sure. Thank you.
Anybody who has a question, press *5, but I will only answer for those people who logged in at 12:30 or before. There are two people that fall in this category so far. One person logged in at 1 o'clock Eastern time. I won't answer you. Okay, 3 people who fall in that category. I'll do those 3 questions. I'm sorry, guys, I have to draw a line arbitrarily because I got limited time. So my suggestion is post your questions. You'll be guaranteed an answer. Sir, go ahead with your question.
Yes, my current H1B is expiring in July.
Okay.
And my project is good till June.
Okay.
So I need one suggestion. Basically, is it a good idea to file an extension with the current project, which is good for quite a few months, or do I need to search for a new project and get the client and file an extension?
I think you should take what is in hand at least. That is my guess. If you're only getting 6 months, take the 6 months and keep looking. That way you have some breathing room, right?
Yeah. So, with any problem, let's say my project is over, after 4 months.
Yeah.
Will they ask any questions? Basically, why did I file if my project is about to get?
No, that happens all the time. That happens.
Okay. So, does it require any amendment if the cities are paying the same MSA?
Sorry, your voice is breaking up. What did you say?
I'm saying this, does it require any amendment if the cities are in the same MSA?
I have answered that question in detail. When the recording is over, listen to the recording. When I post it, that question has been answered, okay?
Okay, so H1 and H4 ready can be filed together in premium processing.
So I'm gonna have to ask you to stop now because I have other people waiting for me. I got 2 more people I'm going to answer. Okay, good luck. Okay, now I'm going to New Jersey again. New Jersey, go ahead, please. You logged in.
Yeah. Thank you, Rajiv. Can you hear me now?
Yes, I can.
Okay, so a couple of questions, Rajiv. The first question is on the EAD extension. I should have asked that at that time, but it was already timed.
Okay.
What I want to ask you is I have a new employer that I have a new job offer starting in August.
Okay.
But I have the EAD from my current employer. My question is, can I extend my current EAD, although I'll have a new job offer from the new employer? So that's number one.
Is that, hang on, is that EAD, hang on, is that EAD 485 based?
EAD 485 based.
And you're doing AC21 portability?
I'm not doing AC21 portability likely because I have a new job profile. That has to be decided by the new lawyers.
But,
they are going forward
now you don't have an option. You don't have an option. You have to file supplement J. You have to file AC21.
Oh, because it's 485 approved, I have to file for AC21 extension.
The law has changed from January 17th. If you are changing jobs now, you have to file supplement J.
Even though the new job profile is not the same as the current one.
Then you can't do AC21 portability.
Okay, understood. Okay, got it. The second question I have is, this is just a news item. You might have addressed it elsewhere. But in your knowledge, did you notice any people with any problems entering on advanced payroll?
No.
Into the country for now?
I haven't.
Okay.
The parole that Trump mentions in his executive order relates to political asylums, not to 485.
Okay, that's it, sir. Thank you very much.
You're welcome. All right, let's. Okay, one more person that I'm answering, and then we are done. This is Missouri. Missouri, go ahead, please. Missouri.
Hey, Mr. Rajiv, thank you for your service to the community. We really appreciate it. My question is, I was on H1B and got laid off, and my I-140 was approved and all that. But we filed for a B2, and now we want to file for the EAD under the compelling reason that came into effect like earlier last month.
Okay.
And I was going through all the forms and all that stuff, and do I have to be on any kind of valid immigrant or non-immigrant status? And if so, do I qualify for that?
I don't think you do. Let me double check. I'm going back to my own chart. Okay. Compelling circumstances. Hang on. You have to be in E3, yes, E3, H1B, H1B1, L1 or O1 status, including grace period. When did your H1 get over?
I got laid off like 2 months and 2 days back.
And you applied for EAD when?
I did not apply. I'm considering applying for the EAD.
From what I see on my notes, it says you've got to be in status or in grace period. So if you're more than 60 days out, you may not be able to get your EAD.
Okay. I'm just off by 2 days.
Yeah, that's what I see in my notes. See, normally these notes I use just to get some preliminary idea, but if I have a client asking me a specific question, I go back and review the regulations. I'm just giving you my preliminary thought. These are my notes, they're secondhand. So I don't exactly know, but I think it looks like it. You've got to be in status or in the 60-day grace period.
Okay.
All right.
Yeah, thank you, sir.
You're welcome.
I'm the last person. I wanted to say something about your service. Can I talk for a minute?
Of course you can.
Like I said, I really appreciate the service to it, and you take a 1 full hour, and you actually went above and beyond your 1 hour. I mean, I don't know. I don't know whoever would do this, but I really appreciate that. I mean, there's another very famous lady attorney, and they claim to be like doing a really good service to the people, but they actually practice differently from what they preach. But you're really like a gentleman. I appreciate your services.
Well, sir, everybody does what works for them. This works for me, so I do it. No thanks necessary. It's my pleasure. Okay?
I'm not trying to indulge in mudslinging on anybody else.
Oh no,
I'm
no.
just saying that.
I appreciate where you're coming from, but you know what? I get back from you guys 10,000 times over what I put in. I don't do it because I want anything back from you. I do it because it's easy for me to do. It helps everybody. I enjoy it. It's something nice for me to do. But as one of the side effects of what I do is that you guys remember us, and I hear from you again and again and again. So it's really our whole practice is based upon word of mouth. We don't have any advertising revenues, so we just rely upon you guys to get the word out. And that's what I've done since 1993 when I first started my practice. So it's been very good for us. It's a good way. It doesn't work for everyone. Everybody has a different style of working, but it works great for us. I enjoy helping people out. It's fun for me. It keeps me sharp, and it doesn't. It's just an easy thing. 1 hour a week is nothing. In 2 weeks is nothing. I'm happy to do it. But thank you for your input.
Yeah, thank you, sir.
You're welcome. Okay, I wasn't going to do any new calls, but I guess there's only one more person. Let's just get that also. Guys, log in early if you want me to answer your questions. Go ahead, California. Go ahead, please. California.
Hello, Rajivji. I had asked this question earlier. So the thing is, my H-1B is in premium processing, and I got an RFP for it.
Okay.
And is there a quicker way? Like, would the USCIS reply to the RFP quicker because I filed it for on premium processing?
Oh yes. Oh yes. Premium processing means this, sir. In premium processing, each time it's a decision that USCIS has to make. They have to do it in 2 weeks. So when you first file the case, they receive it, they have to respond within 2 weeks. If they send you an RFP in those 2 weeks and you respond, again they have 2 weeks to decide.
Okay.
All right?
Okay, so yeah, one last question, if you can. I've been out for 3 months in India, and since they are doing the H-1B processing, so can this be added to that? That's a separate question, basically. So
see the
problem.
Problem is when you have already filed the case, you may not be able to recapture it this time, but you can recapture it next time.
Okay, sounds good. Thank you so much for your help.
Good luck, sir. Good luck. Well, guys, good talking with all of you. Thank you for being here, and I appreciate your appreciation. I really don't do it for just to, I just do it because I like doing it. No thanks necessary. I'll see you again in 2 weeks, and we'll talk some more. Take care, guys. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.